It's hard to walk around the city now without noticing sidewalk sheds in front of buildings. And the reason for that is the Facade Inspection Safety Program, or FISP for short, which is an offset of Local Law 11. So every 5 years, buildings in New York have to make sure that their building facades are safe. In order to do so, an inspection has to be done. The number one issue when dealing with a contract for Local Law 11 work is to make sure that the building retains an architect or engineer early on with the specialized experience to properly assess the building. And the reason why you want to do so is to make sure that the proper scope of work and the plans are up to spec, to make sure that the contractor who's retained knows the full extent of the project and cuts down and minimizes any surprises later on. Once that's out of the way, next is the contract language. And that's why it's so important to memorialize all of the essential terms into a contract, because that's the agreement that they're going to be operating under. And also you want to make sure that the rights are protected later on. So number one is to make sure that there's a proper indemnification agreement within the contract. The indemnification agreement protects the condo or co-op's rights against the contractor later on. The reason this is so important is construction work in New York can be dangerous for a building owner due to the labor law of New York, specifically Labor Law 240. And this will hold the owner of a building strictly liable for any type of accidents or incidents that happen during the course of construction work. So within the indemnification provision of the contract, you want to make sure that specifically any type of negligence or accidents that occur, which would hold the building statutorily liable, are then taken care of by the contractor, and the building's rights are protected there. So the next, and also equally important provision, is the insurance provision within the contract. And when negotiating a contract with a contractor, you want to make sure that the building's broker is involved from the beginning to review the terms and make sure that the proper insurance is in place and that it'll appropriately protect the building with regard to any losses. Also, once the insurance language is approved, a lot of times a building will receive a certificate of insurance listing the building as an additional insured. You cannot rely on this paper, and the reason is we've seen it in the past, whereas a building receives a certificate of insurance claiming that the building is an additional insured, and later on an issue happens and there's no insurance. So it's very important that you receive the insurance documents as well as any endorsement that names the building as an additional insured. Lastly, Local 11 is a long process, and you want to make sure that the process moves along quickly. So there are some terms that can be added to a contract to kind of push a contractor along at times, such as a liquidated damages provision if the contract is not finished at an appropriate time, and also an attorney's fees provision, which would allow the board attorney's fees in the event that there's any type of lawsuit that follows on. So these are just some examples of important terms that are required in contracts. There's many more, but this will get you where you need to be.